assessment order, and we have to also cross check with the corporate data. Now, in some cases, we'll also go through it in the later stage. We'll see how the differences or the disputed case, statutory dues, are being dealt with. I mean, where the corporate debtor is contesting, say, for wrong credit of input VAT or something like that. We'll see in the next slides. So, how to deal with such situations. For the other operational creditors apart from workmen employees, the contract or the purchase order or the work order is the key thing to determine whether the conditions of the transactions. For example, if any delayed interest is to be paid, if any uh, what are the payment terms. So those all things are covered in the contract and purchase order. So those are the key areas which needs to be looked into. Invoice is one of the important part. And if any invoice, when we see that, as Shalini said, that we see a lot of lacking in accounting, especially due to the unavailability of employees or the system due to the stressed condition. So we see in many a times we see that invoices are not accounted in the books of the corporate debtor, and so there is a difference where the claimant is challenging that the material was supplied or the service was rendered. So there, to validate those, the MRN, which is the material receipt note, or any kind of service completion certificate which might have been issued by the corporate debtor or its personnel to the operational creditor, that can be revisited or checked upon. Now, any same case, same for the all these all the type of claimants. If there is any kind of decree or any order that has been given on any kind of disputed or long pending dues by any of the authorities, that is also to be taken on records and to be accepted or admitted as per its acceptability. Now, moving on to the workman and employee. So basically, their pay slips and their appointment letter are one of the are the key documents that are to be verified. Nowadays, it has been it is very important, the employee claims after the judgment of JTROS regarding this gratuity and PF, that then it needs to be settled in full. Now the employees and workmen claim has become very important, and the bifurcation of the claim related to gratuity and PF are to be looked into and must be computed by the IRP or RP, as the case may be. And it should be informed to the PRAs. For other creditors, apart from all these types of creditors, they are form a part of other creditors, and basically for them also, if they have any agreement, invoice, any kind of order for any kind of tribunals, that needs to be checked into and matched uh, with the records of the corporate debtor. So now coming on to specifically the issues that are faced in real estate sector claims. So one of the challenges that we face, that when this amendment came, or rather it is to be said that this section 5 subsection 8 was clarified uh, by the insolvency committee, that the financial home buyers will form a part of financial creditors, and they have the right to participate in the COC, and they have a right of voting share. Then the next question comes in, whether they are eligible for any kind of interest or not on the payment they have given to the builder. Now, whenever it comes to a financial claim, as per the code, it is eligible for interest because of its time value of money. So obviously they are eligible for interest. If the interest is pre-agreed, for this we have to look into the builder buyer agreement. As I said during the documentation, it is a very important document to see all the terms and conditions of the transaction. So if it is specified, then in case of delay or in case of any kind of default by the builder, the buyer will be eligible for a certain percentage on the money paid invested by him or paid by him. Then it's fine, that rate needs to be taken care of. If it is not covered by any of the engagement agreement, then it is also given in the regulation of IBBI, regulation number 16A, that clearly mentions, I will quote unquote, that the voting share of a creditor in a class shall be in proportion to the financial debt, which includes an interest at the rate of 8% per annum, unless a different rate has been agreed to between the parties. So, if the agreement doesn't cover any rate of interest, then the home buyers are to be given 8% of interest rate on the payments they have made till the date of insolvency commencement. Now, if the payments are made in installments, it is preferable to calculate the 8% interest from the date of installments paid till the date of insolvency commencement. So the interest claim, and it should be admitted, it is admitted as a part of financial claim only, along with the principal amount paid by the home buyer. So the interest claim is admissible claim. Now the claim from home buyers who has a decree. Someone was asking, so this will probably we'll discuss in this section. Who are a decree holders? You know, there are two three things. Sometimes it is, we have seen that the default has happened from the builder side, is fine, I mean, in that case, and sometimes the default has happened from the buyer side. So there are two sides of it. But anytime if a default happens from the builder, the buyer can take it to the different adjudicating authorities like RERA, like any of the uh, courts of law, and they can have their orders or decrees and they can claim based on that. So when they file claim based on the decrees, so it is to be seen what is the what is the outcome of the decree and what is the demand that is made in the decree. So if this is the demand in relation to the refund of the money invested by the home buyer for purchasing a flat, that decree allows him to file that claim along with whatever interest rate and whatever this charges, court charges has been given for reimbursement, allowed for reimbursement. He is eligible for that as financial creditor. Now, I was hearing a question: whatever decrease in terms of rent or in terms of uh, other delayed compensation or whatever it is, in terms of harassment or all other things. So there we'll have to look into, and a general practice that we have found in many of the cases, that as those are not directly related to financial assistance or the financial claim as specified in the code, those can be, we have seen in the practice that those are treated as other creditor claim. But it is also to be informed to the prospective RAs that they are a decree holder, but due to the nature of their demand, they have been categorized as other creditor, but they, on the other side, same side, they are also allottees, and they may have their original refund claimed as financial claimants. and the PRAs are to decide on their proposals for these decree holders.
But sir, there are cases wherein the underlying nature of the claim has to be looked into. It is as observed by the Supreme Court.
Yes, of course, sir.
The basic
Yes.
nature of the claim will determine the classification of arbitration award. This is what the latest the thing is going on. The basic and underlying nature of the claim will determine the classification of arbitration awards by a home buyer. I mean, this is what my understanding. It may not be correct also. So you please, I think Dana Bank case, and there are few cases which have been reported in this regard. One I remember, this is Dana Bank case. So yeah, please.
Yeah, of course, sir. You are absolutely right, and that is what I also covered. That if it comes under the purview of the financial claim, as has been given, as has been mentioned in the code, it always comes under the financial claim, as I said. But any decree which is not related to, I mean, the amount paid or the assistant amount assisted by the home buyer, or not in a nature of financial claim, that may form of a part of other creditors, but that still holds a decree, so it should be informed to the PRS home, that means prospective resolution applicants, that these are not in the nature of financial claim. But I completely agree with you, and this is very important to assess whether they are in the nature of financial claim or not.
That is right. Because, the decision making or the COC constitution is also linked to categorization of the claim, which in turn needs to be linked to the basic type of claim, as you are saying. And that is what we are also trying to bring out, that yes, the decree has to be taken into account, but on what grounds it has been given, for what grievance, and is that amount which is given in the decree or the award, is that linked to time value of money or financial assistance provided by the home buyers for construction of the project, or it is some other grievance that is being addressed through that award, and accordingly, based on the nature or the type of the claim and the award, the categorization should take place.
Sorry, I'll just take half a minute. So, for
Please.
example, arbitration award given to a home buyer for rent loss because of the delay in handing over the apartment. So, where you will place this award? For example, 1 crore has been given as an award for rent loss by a home buyer for a home buyer. Will that be a financial claim or a other creditors claim?
Sir, yeah, so we need to look into the, if there was any rent loss. You mean to say rent loss? That means the home buyer was,
Yeah,
living on rent.
on the committed, I'll make it more clear, sir. On the committed date or on the specified date of handing over, the apartment was not handed over. Say after 4 years or 5 years only. I mean, it is not still handed over yet.
Mhm.
So, in meanwhile, the home buyer got an arbitration award. The arbitration award was basically for the loss of rent, in the nature of damages. Where will you place this amount which has been
No,
received
so
as an
the
arbitration award
loss
for
of
rent
rent.
loss?
So loss of rent means the home buyer was staying on rent, right, for those 4 years.
He
No,
was
sir.
committed. He was committed a rent, if I am understanding correctly, the way several property developers
Correct.
commit that you will be given a rent
Yes.
on the basis of this apartment, some amount they commit. But there again, sir, that as Abhirup was mentioning, the we have to look at the what the code says, and also what is the intent. The intent firstly was to, yes, give home buyers rights as financial creditors because they provide financial assistance to put in place a project. At the same time, there are cases, and we have discussed some of them subsequently, wherein any type of committed return offered to any home buyer, that always complicates the situation and it is not looked at favorably by the courts. If it is a rent loss, that is a type of compensation that is getting. But what we have been doing, and Abhirup, you can also share your views, we do not think that that strictly qualifies as financial claim, because what qualifies as financial claim has been spelled out, the amount of assistance provided, and there's an 8% rate of interest specified there unless something else has been agreed as a rate of interest. A rent loss is may not exactly meet that criteria. That is our view, but of course it is subject to interpretation.
Yes,
Yes,
that
sir.
is a
Thank
kind
you.
of compensation. That is a kind of compensation that might have been committed for the delay. But what we have seen in the cases, and what we have also seen from some of the legal advisors in the market, that such claims which are not directly, as Shalini said, that whatever amount has been paid by the allottee, and on the same, it carries a time value of money, so interest he is eligible for as a financial claim. But particularly coming like the situation you are telling, that a rent loss, that means for the delay whatever rent would have he has lost, so that ideally does not form a part of financial claims, so that can be treated as other creditor claims. But again, I'm saying that the decree has to be informed well to the uh, PRAs, so that they can have their provision for separately for these decree holders. Otherwise, these cases, delays the resolution process, and most of these decree holders goes into, NCLT or NCLAT for not approve for, dismissal of the resolution plan, because their interests are not covered equally. So moving on to the next slide, this is one of the other aspects, that how to deal with the claims of cancelled allotments. So it is very common in real estate sector that the home buyers, they the home buyers lose their faith on the builder because of their delay or the stalled projects. So in some of the cases, we can see that the home buyers stops making any payment because the construction has been stopped or getting longer time or delayed. So they lose faith and they don't make any further payments. Now in this situation, what the builders do is they cancel the allotment of the home buyers. Now, when they cancel the allotments of the home buyers, so there are two things that needs to be checked into: whether the demand raised by the builder is legitimate, if it is a construction linked plan, payment plan, whether the construction has happened for the demand that has been raised, and if the home buyer has genuinely defaulted or not. On the other side, such things are also being contested by the home buyer before many of the adjudicating authorities, and there we also see some kind of decrease or order that may have the home buyer has got for this forceful cancellation of unit. So it is not a real cancellation, they should be termed as allottees and something like that. So when you have that, they surely forms a part of this financial claimants. Now sometimes we also have that the buyer has genuinely failed, in making the payments, and he doesn't have any kind of decree or anything else. But obviously, he is eligible for a refund of his money. Now, the refund of the money depends, on the terms and conditions that are specified in the builder buyer agreement. Usually, we see a haircut of the EMD amount when the unit is cancelled, earnest money deposits are deducted, and the rest of the amounts are, you know, or in sometimes we also see that even the brokerage paid by the company has also been deducted, and the remaining amount is paid back to the uh, home buyer or the cancelled LOT, or it is payable to the cancelled LOT. So that needs to be taken care of. Sometimes in different agreements, I have also observed that the condition says that the amount of cancelled refund will be crystallized or eligible only if when the unit is resold to someone. So before admitting the claims, it is also to be seen whether if such conditions are there in the contract, builder buyer agreement, then we have to see whether that has really been resold or not. So there is a regulation in sections. There is a section of 18(1) subsection B in RERA which says that if the promoter fails to complete or is unable to give possession of an apartment, plot, or building in accordance with the terms of the agreement for sale, or as the case may be, duly completed by the date specified therein, he shall be liable on demand to the allottees in case of allottee wishes to withdraw from the project. This is self withdrawal without prejudice to any other remedy available to return the amount received by him in respect to that apartment, plot, building, as the case may be, with interest at such rate as may be prescribed in this behalf, including compensation in the manner as prescribed under this Act. So this is said in RERA that this is a willful withdrawal of the unit due to delay. So thereafter, this on the same ground it comes on the claim that relates to the compensation asked for the delay. So, see, so we have to again be cautious to check the builder buyer agreement to see whatever compensation has been offered for the default or delay. It may be a percentage on the amounts paid per annum basis or quarterly compounded basis. It may be a per square feet rate, 5 per square feet per month or something like that. So that needs to be checked, and accordingly the same needs to be admitted. But again, also it has to be checked that the delays compensation should be calculated as per the completion deadline mentioned in the builder buyer agreement from that date till the date of insolvency commencement. If there is any grace period, like it is usually seen that the completion date is this, but another grace period of 6 months can be allowed. So in that case, we have to take that grace period, and after that we have to calculate the compensation from thereafter to the insolvency commencement date. Now there is, we see that claims filed by resident welfare association. These claims generally form a part of, other creditors because these are not in financial claim nature of financial claim. So what the resident welfare association wants, they basically when they file claims basically on the lack of wherever there is a lack in the maintenance of the common area or facilities, the welfare association claims on behalf of that. So What becomes difficult over here is to verify, because for example, there are no proper bills, there are no proper invoices on the concerned party, and probably they have just estimated that, say for example, in a residential project they have claimed that 110 street lights are not working. So it is not feasible for the IRP or RP to go and verify whether there are 108 lights are not working, or the generator, five generator, two generators are not working. It's not possible neither to assess their values. So there it has to be, mostly it has to rely on the best information available in the records of the corporate debtor, and accordingly the facilities which are to be, whatever common facilities were to be given are to be valued and are to be admitted. But this doesn't form a part of financial claim, generally the claim by residents association. Now we'll come to a section which says about this intercorporate deposit. So it is very much important, we have seen many a times for financing, the builder, through its SPVs or from its parent companies or whatever it is, they used to receive intercorporate deposit to build up a certain project. Now, whether to admit that claim or not, firstly, by nature, it is a financial claim, but also it is very much important to see whether this intercorporate deposit is supported through agreement, board resolutions, sanction letters, bank statements, everything that suggests that yes, it is a genuine intercorporate deposit. So if we go by the judgment of NCLT Kolkata bench in the CVU Markens versus Ashish Vincom Private Limited case, we'll see it says that intercorporate deposits are financial debts, but in a transaction of a deposit of money or a loan, a relationship between the parties must come into existence. Mere transfer of money from one account to another account would not constitute loan or deposits unless the intention of the parties are considered and substantiated with the valid documents. So this judgment clearly mentions that the intention of the transaction has to be a loan, and it has to be supported by documents, and the relationship between both the parties, who is the lender and who is the borrower, there must be a relationship. It's not between just two companies who has just sent or rolled some money through other company. So this is a very important judgment that is to be followed before admitting any ICD. It is
So,
not just.
yeah, what is the meaning of this relationship? For example, if a real estate company borrows intercorporate deposit from another company at a certain rate of interest, is that relationship enough, or let's say it's a pure financial transaction? Is that not an intercorporate deposit?
Sorry, real estate company borrows from.
Let's say a real estate company borrows intercorporate deposit from another company at it's a pure, let's say, financing transaction at a certain rate of interest. So is that good enough to qualify under this?
No, but yes, it is good enough. But what is meant here is that what is the interest of that lending company is also to be checked. This relationship means, suppose a steel manufacturing company, why he will be investing in a real estate company, I mean, or any other company. I mean, he is
Maybe
not
it's
a
a pure, maybe it's
SPV.
a pure financial transaction for him that he earns some rate of interest for this. It's an investing activity for him.
Fine, that's fine. If it is supported by that kind of agreement where it says that this is the period, this is the repayment period, this is the interest rate that we will carry, these are the default conditions. If
Yeah,
all those are there, then it's a ICD.
yeah, correct.
Right. I agree completely. Sir, just by borrowing is not sufficient. I mean, all the backups have to be there. And what we find is that in many cases, particularly when it comes to ICDs, they are not backed up by any contract or any agreement which specifies the terms and conditions. So, in that case, admitting them, there isn't sufficient ground to admit that type of a claim. And
Right. So,
particularly, yeah.
right. So in many of the cases, as Shalini rightly said, we see just there is a balance confirmation which has been submitted by the claimants. Only a balance confirmation that see this, your corporate debtor has given me this balance confirmation. Or sometimes we see that they are claiming that see your balance sheet, there is an amount, liability booked on my name. So that's an ICD, but it's not like that. It has to be supported through proper agreement and intention of transfer of the amount. And then it will only qualify as the financial claim.
And this will be an unsecured creditor only, no? It won't be a secured financial creditor, no? This
Yes,
intercorporate deposit.
of
Yeah.
course. Yes, correct. Until and unless any security is created, and for that creation of security also, if there are any other lenders who have charge on it, they have to issue the NOC, and then only you can create a second pari passu charge also.
Okay.
Now, claim against corporate guarantee. So we can see situations where uh, the builder has given issued corporate guarantee to any of its to any of the lenders of its SPVs and all. That in case their SPVs, whosoever building any other project, if they fails to pay the amount, they will pay the amount in full or in partial. So this also puts the builder, as the kind of indirect borrower. So in that case also, the lenders of these its SPVs based on the corporate guarantee given by the builder can file claim in the CIRP of the builder, though it's not a direct claim. In that case, it is also necessary to verify the terms of the corporate guarantee. But generally, when it is a pure lending by its SPVs or any other company, and where the corporate debtor has given the corporate guarantee and taken the risk of paying that financial liability in case it is failed by the original lender, then it is considered as a financial claim, and it can be taken as a financial claim, and respective voting shares can be given to the lender or the financial creditor, and he should also form a part of the COC. Now, the other thing that we see that when this first situation, stress situation comes in, the lenders try to mitigate the situation through debt restructuring, and one of the common scenario in debt restructuring is that to convert some of its amount or dues into equity shares. Now, when the CIRP starts, even when the debt restructuring doesn't get success and the CIRP starts, sometimes it is seen that the lenders have filed claim for the debts which have been converted to equity during the CDR, saying that CDR corporate debt restructuring has not been successful. So we are claiming that it was a part of our debt. Now we are claiming for the same, though it has now been converted to equity. So firstly, in such cases, it is to be seen that what the debt restructuring agreement says. If it says about reconversion of the equity to a debt, then it's fine. But in most of the cases, we see that there is, no reconversion clause. So in such cases, taking these equity shares as financial claim will not be a correct step, as has been seen in various cases. Now, this matter has also come up in NCLT Hyderabad in the case of HVRCL Limited. In this matter, the Canara Bank lodged a claim for the converted equity shares, for the debt that is converted to equity in the CIRP. And the IRP of IVRCL did not admit it, that and said that the equity portion cannot be included as claim. Now, Canara Bank appealed to the NCLT Hyderabad bench, and they said that the debt converted into under the CDR, corporate debt restructuring, is only for revival of the debt and doesn't amount to acquisition of shares by the banks. So they didn't want to take the shares, but it was just a conversion of debt for the revival. Now, what they also plead before the NCLT is that as far as the revival has not happened, Canara Bank and any other lenders who have the same scenario, their portion of equity share should be reverted to the debt. Now, in this matter, the contention of it reads as the contention of Canara Bank that the conversions of share is not absolute was rejected by the NCLT, and the action of the RP in not admitting the claim was upheld. So it was accepted that it should not be admitted in financial claims. What the authority has said that the shares have been issued to the lenders, which was acted upon by the lenders. So the intentionally, that means they intentionally converted it, they agreed to convert it, and it was acted upon. Actual conversion was done, they signed the CDR agreement. So the question of lodging any claim in respect to the equity portion does not arise. So it simplifies the matter that when they have agreed to a conversion and when there is no provision for reconversion from equity to debt, then that action has been exercised by the lender, and so the equity doesn't form a part of financial claims.
So basically, they can't have the best of both worlds. That's the, I think, summary.
Right, right, right. Exactly, sir. Now, here comes some situations which is like claiming against long pending disputed cases. So, in every CIRP, irrespective of it is in real estate sector or any other sector, this kind of claims are very common. That the company denies the, the demand, and the other party who is the claimant, he emphasizes on the dues. So here, it has to be checked whether such matters, in most of the cases, such matters must be, subjudiced against any of the authorities. So if any order has come in favor of any of the parties, that has to be, accepted. That is very well. If the matter is still pending before any court and the books of the corporate debtor is not showing the kind of liability that has been claimed for, the best thing to do is what the market practice says, that whatever amount is supported by the records of the corporate debtor and its available information, that can be admitted directly. Any amount which is higher and over the best available information and which is being contested in any of the courts or any other fora, which is yet to be decided or yet to be ordered, that can be placed as contingent liability in claims. But it is also to be ensured that such kind of contingent liability are specifically reported to the PRAs so that they have a perception of any liability that may or may not come out in future. so that they can have a provision for that. Now we'll come to the demand raised by the government authorities. So here also we see a lot of, as I was saying, when we are discussing on the statutory claim and all documentation, we are just discussing that. When the demand claim is being filed by the government authorities, we see a lot of difference between the claimed amount and the records of the corporate debtor. So basically, we'll find two, three categories. One is that the corporate debtor denies for certain demands, and it says that he has complied with that. Secondly, like some kinds of concession in export duty, import duty, concession in import duty, or in other rates with some export obligations and all. So they are, sometimes we find that the corporate debtor is contesting. Sometimes we find that that the government has charged additional penalty and interest. That is why the claim amount is very much higher than the whatever in the books of the corporate debtor. So those cases actually needs to be verified on a case to case basis. If there is a demand notice or demand order that has been already raised and is not challenged by the company in any of the against any of the authorities, then that government dues obviously form a part of operational claims of the corporate debtor. If it is being challenged before any of the adjudicating authorities and are still under adjudication, or if the final assessment order has not been released and the amount has been estimated only based on show cause notices, then again we have seen a practice that IRPs or RPs consider this portion as contingent claim and inform to the PRS so that they can appropriately provide something for this, or provide in their resolution plan for such kind of things. Uh, we'll cover this very fast in short, because these are related mostly with workmen and employee claims in all the sectors, but we are covering here the real estate sectors, but it is a common phenomenon. So no work no pay. So no work no pay, when the corporate debtor issues no work no pay notice to the workers because of the shutdown of the project. So now here two things has to be looked upon. One, when the claims are being filed for the period of no work no pay, the RP is not an adjudicating authority to decide whether the corporate debtor at that point of time before initiation of the CIRP took a right decision or not. So if the no work no pay is documented in a well manner, then he or she, the IRP or RP, can avoid taking any claim for the no work no pay period. But here we have to we have to keep in, we have to, it is very important to assess whether these employees or workmen have appealed before any of the state or central government authorities for their rights, and they appeal that this no work no pay is a willful fraud by the uh, builder, and if they have any kind of decree from any of the authorities that they are entitled for payment for this no work no pay which has been forcefully imposed by the builder, in that case we will have to comply with the decree and we will have to take their claim in the regular employee or workman category. Now coming to the claim against gratuity. So what I was just telling, it's a very recent judgment even in case of Jet Airways. The gratuity now, PF and gratuity are to be paid in full by the resolution applicants. So we have to, whatever we have to check when we are when we are dealing with claims regarding gratuity. Firstly, we have to check whether the employee was eligible for gratuity. That means as per the Indian Gratuity Act, whether he has worked for 5 years. in the same company at a stress, whether he has resigned, because the gratuity becomes crystallized only when the companies get separated from the company, or when the employee gets separated from the company. So the gratuity gets crystallized on that case only. On the other side, so we'll have to admit such claims in regards to gratuity, and we'll have to specially emphasize on the numbers to be informed to the PRAs for covering in their resolution plan, especially after this recent judgment of Jet Airways. Now, also, what needs to be done in this case for gratuity for the employees who are eligible for gratuity, that means they are continuing for more than 5 years in the same company, but their gratuity has not crystallized as they are still working in that company, not resigned. Those provision for the gratuity for those people should also be what provision has been created and what are the numbers of the existing eligible employees are also to be given to the this PRS, and also are to be checked whether they are being properly maintained in the gratuity fund created by the company. Moving on to a section that says about mutual set off. So we also see this in the claim form, that whether any amount is to be set off mutually. So yes, this mutual set off applies if the corporate debtor is also, there is some receivable by the corporate debtor from the claimant, the mutual set off can get place. But we have to remember one thing here, that a good and common practice you to have mutual set off only against the same contract. For example, if I have given some advance of for any of the I have given advance for any lease or any rent, and there the rent is payable under the same contract, it can be adjusted. But if those are between two different projects, now we will also, when in the subsequent slides, we also see that in real estate sector we have a judgment that says that the real estate sector, a company under real estate may not always go into CIRP as a whole, but it would be a project wise CIRP. So in such cases, any adjustment of receivable against payable against two separate projects are not likely to happen. So mutual set off should only happen if they are related to the same project and same contracts. That is the ideal uh, situation to do a mutual set off. Now we will look after this some of the overlapping claims. Overlapping claims, what are the overlapping claims that we see in real estate sector? That we are discussing on the tripartite agreements where the allottees take home loans from any of the financial institutions or banks, and there is a tripartite agreement between the builder, allottee or home buyer, and the and its lender who is giving it the home loan. So there what happens, the property, or the flat or the home is mortgaged to the lender. So in such cases, the financial institutions also may can file a claim for all its allottees. Now here typically two things has to be checked. If the allottee has filed his or her own claim, and for the same amount the financial creditor, the lender has filed, its lender has filed the claim, then it's a overlapping or duplicate claim. We can't take both of them. We have to take either of the claims. Now in this situation, what is to be looked into, whether the home buyer has defaulted in its EMI or not, and whether the uh, its lender, that is the bank or financial institution, has invoked the mortgage or not. If so, then the financial institute, it's the claim of the financial institution is to be taken. If the home buyer is paying its normal EMI and there is no default in its account, then primarily the allottees or the home buyers should be treated as the financial creditor and they should be admitted in claims, not the financial institution. Now it can also happen, suppose in a flat of 1 crore, the home buyer has given 10% of it, 10 lakhs, and 90 lakhs has been funded through a home loan. In that cases, we can take both of their claims, but we have to ensure that we should keep the portion of investment, respective portion of investment, that should only be admitted for both of them, so that it should not club up to a duplicate claim. Now, we will go through some key judgments in the real estate sector. Shalini, would you like to take it up?
Yes. So we will take up some landmark judgments which have impacted real estate sector CIRP. So we have selected some 7 judgments, and there are some ancillary ones also which we will mention as we go along. But we will deal with primarily these 7 in detail, and a few related ones we will touch upon. So, in terms of sequencing, I think maybe just on account of the chronology, I think I would like to discuss case 5 first and then, come to the rest of the sequence. So, case 5 is the one, the main paradigm shift which came about in real estate sector CRP was when the IBC was amended to allow home buyers to be categorized as financial creditors. This was not there originally when the code was introduced. It came about subsequently. As we all know, the code has been evolving, it has been responding to the needs of various stakeholders, to the feedback of different sets of interested parties in the whole resolution process. And this came about subsequently. And however, if we go to the first part, just to give the background, this was even though IBC subsequently permitted home buyers to be classified as financial creditors. In this particular case, this was challenged, and it is a landmark case because the Honorable Supreme Court has upheld the constitutional validity of the enactment to the code, which enables home buyers to be financial creditors, which enables them to be part of the COC and have a right, have a say in the decision-making process for the resolution. So we can, move on to the next slide. So here, what we are saying is that some of the petitioners had raised the following points challenging the code. The judgment is against the object of the code to maximize value of the assets so that the shareholders of a corporate debtor do not suffer from bad management or poor management. There may be such situations where the builder completed building projects in time and in every way compliant with the law. However, petitions may be filed by the allottees under the code to blackmail them into making payments which would divert funds which are otherwise to be used for the purpose of the project. So these are the arguments which were being given by the parties who were challenging this aspect. A perfectly solvent company having perfectly good management may be wound up if there are no resolution plans or all resolution plans are rejected by the committee of creditors. Including allottees of real estate projects as financial creditors would not only be unworkable as thousands of petitions would flood the NCLT but would be both arbitrary and unworkable when this large number of disparate persons is represented on the committee of creditors. So this was argued very extensively. There were arguments used like, using a sledgehammer to kill a gnat, which means where it is not required, it is being tried to fit the IBC to solve issues in projects where it is not necessary. That was the argument being given by the people challenging the admission of home buyers as financial creditors. Another point mentioned, at the time of execution of an agreement between the allottee and the real estate developer, what is agreed is that in return for money paid by the allottees, a flat or apartment would be allotted. It is only in the event of breach of the agreement on the part of the real estate developer that monies are to be refunded, which does not include allottees within the definition of financial creditor. The whole aspect of why and how a home buyer can be construed as a financial creditor was questioned. Thereafter, of course, the judgment came which upheld what had been introduced in the court, and it also, this is a very detailed judgment. It goes into all aspects of each of the points that have been put forward by the parties challenging this amendment. It goes into details of the deliberations of the insolvency law committee, which proposed home buyers to be included as financial creditors, and gives a detailed rationale based on those deliberations and based on the various points and counterpoints presented by both the parties to ultimately uphold this milestone amendment. So we are just summarizing some of the key things here. The Insolvency Law Committee deliberated the agreement. So this was mentioned by the Honorable Supreme Court in its order. And it is important to be noted to get the whole basis and get the holistic view of how this has come about, and it has also been upheld in the legal forums. So they said that the Insolvency Law Committee deliberated the agreement for disbursement of money by the home buyer is for delivery of a building or to be constructed in future. The disbursement of money is made in relation to a future asset, and the contracts usually span for a period of 4 to 5 years or more. The Insolvency Law Committee deliberated that the amounts so raised are used as a means of financing the real estate project and are thus in effect a tool to raising finance. And on failure of the project, money is repaid based on time value of money. So this was the whole crux of the argument which was used to classify home buyers as financial creditors. One, they are acting like finance providers for the project. Real estate developers, the company is getting the project completed based on the disbursements or the installments that it receives from home buyers. Home buyers are therefore to be treated as financial creditors. If they do not get their flats on time, then they are to be refunded based on time value of money. All these rationale point towards the fact that home buyers are indeed financial creditors. It goes on further to say, it can be seen that the Insolvency Law Committee found as a matter of fact that delay in completion of flats, apartments has become a common phenomenon, and the amounts raised from home buyers contribute significantly to the financing of the construction of such flats and apartments. This being the case, it was important, therefore, to clarify that home buyers are treated as financial creditors so that they can trigger the code under Section 7 and have their rightful place on the Committee of Creditors when it comes to making important decisions as to the future of the building construction company, which is the execution of the real estate project in which such home buyers are ultimately to be housed. It was communicated in the Supreme Court judgment that the explanation was added by the Amendment Act only to clarify doubts that had arisen as to whether home buyers or allottees were subsumed within Section 58F. The explanation added to this section of the by the Amendment Act does not in fact enlarge the scope of the original section, as home buyers or allottees would be subsumed within the section as it originally stood. The Honorable Supreme Court further held that allottees or home buyers were included in the main provisions with effect from the inception of the code, the explanation being added merely to clarify doubts that had arisen. So the Supreme Court upheld the classification of home buyers as financial creditors on all respects, and in fact on there are some other points which come out in that judgment. For example, the contention that the opposing parties had that if this is allowed, then any home buyer can take a real estate company to insolvency, and a perfectly good company can be wound up because of that. So that was also countered by saying that if there are frivolous claims, if there are malicious claims, then the other party, the developer or the company, will have the right to defend itself, to showcase what it has done, and it can be argued. But definitely, the fact that home buyers are financial creditors cannot be contented with. So this judgment is very important. It is cited in almost all real estate cases, and it has, since the amendment and this judgment further upholding it, home buyers are now part of the committee of creditors, which has brought about a complete shift in the way real estate projects are addressed or resolved under the code. So I wanted to take this first because this was in chronologically, this was the first, and then we'll come to case one. But before that, I'm just wondering whether we can take I'm requesting ICICI, can we take a 5-minute break? Anjali, are you there? Or if all the participants are fine, we can just take a break for 5 minutes.
Yes, ma'am.
Yeah.
We can take it.
Yes.
We can resume at 11:50. Now is
Yes.
11:42. We can resume at
Okay.
11:50.
Yes, let us resume at 11:50, and then we will take you through the rest of the judgments and the final wrapping up session and the discussion. So
Thank
we will
you.
restart at 11:50.
Okay.
So welcome back, everyone. I think we can restart as it is 11:50. So yeah, we will now go through the rest of the judgments. But again, wrapping up on the first one. So as I discussed, various points and counterpoints were there. Ultimately, the Supreme Court upheld the treatment of home buyers as financial creditors. There were various arguments also given on the fact by the opposing parties that if there is already an act which is RERA, which is there to address the concerns of home buyers, then treating them as FCs, giving them decision making powers, etc., under the IBC, it is contrary to the purpose. There again, the views of the Honorable Supreme Court were very clearly spelled out in their order that RERA is only an additional mechanism. RERA is available and continues to be available to aggrieved home buyers, and RERA proceedings are in addition to the mechanism available under the IBC. So that was also clearly mentioned, and that has become the ground for various other rulings. That pioneer ruling has been referred in many cases, including the one that we will now discuss. So this is the one which pertains to reverse CIRP. Again, this is something which is very specific to the real estate sector. So before I continue, Anjali, I hope we can continue, right?
Yes, ma'am. We can.
Yeah. So this particular case was, as I mentioned, pertaining to reverse CIRP, wherein again, this is a situation which comes up only or largely in real estate sector. At least we have seen it only in real estate sector, wherein there is a possibility or a scenario of project-wise insolvency. So we have, I think all of us would have heard of situations where certain companies have various group entities, sister concerns, and there is a ground for consolidated CIRP. There are some cases in which that has happened also, and there are also developments happening in that regard, in the sense that a formal consolidated mechanism is proposed to be put under the code for group insolvency. But in real estate sector, reverse CRP or project-wise CRP is something which comes about as a need for home buyers, as a need for creditors. Apart from that, there is a situation wherein home buyers, due to their main objective being the delivery of the flat, what they need is not necessarily recovery the way the banks or financial creditors want, but what they want is delivery of their homes. So in case interim finance is available from a promoter entity, they are willing to take that in order to resolve their project rather than straight away getting compensation in the form of finances or recovery. So this particular case is also one of the key judgments in this sector, and it pertains to the Flat Buyers Association Winter Hills 77 Gurgaon versus Umang Realtek Private Limited. So here NCLAT New Delhi has given this order in 2020. The brief background of the case is that the allottees, Rachna Singh and Mrs. Rachna Singh and Mr. Ajay Singh, had moved an application under Section 7 of the Insolvency and Bankruptcy Code for initiation of CRP of Umang Realtek, a real estate company involved in construction of flats and apartments, which was admitted by NCLT Principal Bench, New Delhi. Later, the Flat Buyers Association of Winter Hills, 77 Gurgaon, and the original applicants, Mrs. Rachna Singh and Mr. Ajay Singh, allottees, wanted corporate insolvency resolution process for resolution, but did not want approval of any plan of a third-party resolution applicant, and so appealed for the same to the Honorable NCLAT New Delhi. So they want CRP, but they do not want approval of a plan through a third party. And this also they are appealing after they have filed for Section 7. Very unique and interesting situation. Once an application for CRP of the corporate debtor is admitted and an IRP is appointed, it is the duty of the IRP or the RP to keep the corporate debtor as a going concern. However, in case of a real estate infrastructure company, the only business is to build and complete flats or projects, and thus maintaining the corporate debtor as a going concern is a hurdle that is almost impossible to cross. Given the grave situation, most real estate companies are pushed into liquidation, and the same does not serve any benefit of the company or its creditors. If a resolution plan is not received or a resolution is not worked out which achieves the original objective of delivering completed units to the home buyers. Thus, reverse CRP has been introduced in the cases of real estate infrastructure projects in the interest of the allottees and survival of the real estate companies and to ensure completion of projects. The aim of reverse CRP is to get the twin benefits. The first one is to save the company as a whole from insolvency, and the second is to give possession to the allottees in the project. So the home buyers come within the meaning of financial creditors, as we have seen through amendment to the code, through the judgment, pioneer judgment, which upheld their status. So they come within the ambit of financial creditors that is well established, and they possess voting rights for approval of any resolution plan. However, the issue with respect to the is the lack of commercial knowledge or expertise to assess the viability or feasibility of the corporate debtor, unlike that of financial institutions, banks, and NBFCs. Still, these allottees have been provided with voting rights for approval of the plan. Another difficulty faced is that distribution of assets of a real estate infrastructure company. How should that be done as per the resolution envisaged under the code? That is a question mark in real estate.
One small question.
Yes.
So this reverse CIRP means what? The CIRP which was initially admitted will be taken back, or what does that mean actually?
No,
So, may I, Shalini?
Yes, go ahead.
So this reverse CIRP is that it especially has been introduced in real estate sector only, given the nature of this sector, what this judgment has been given by NCLAT, that the promoters who had originally the the vision on the viability of the project, the plan of the project, the construction of the project, the vendors who have hold on all these things, if they go out of this process due to initiation of this CIRP, then this process gets hampered. Whosoever will come from outside with a third party, whosoever will come with a resolution plan, their resolution plan may not be, may not complete the project or its its intention, I mean, to develop the project in the original manner as was promised. So it was set out that the CIRP will happen. Reverse CIRP is something where the IRP or RP will be there and he will be monitoring everything, but no third party resolution plan will be accepted, while the promoters from the outside will be assisting by giving the funds and continuing with the constructions, but they will have no direct rights on the company, and they will have, everything will have to be monitored and approved by the IRP, but the construction and funding rights will be, construction and funding will be, can be done by the ex promoters, and the original terms of the agreements, builder buyer agreements, and how the payments were to be received, those will be follow the same process, but will be monitored by the IRP.
So, which means that effectively the original purpose of the project in case of Umang will continue. The buyers will get their flats and all that. Just that it could be completed by somebody else. That's
No,
what
it won't be completed by somebody else. It will be completed by the promoters only.
Yes.
Umang in this case.
Sir, without
It was not Umang, but a promoter entity.
Yes, promoter entity of Umang. It was
Correct.
the promoter entity of Umang.
So
Sir,
if we can display the next slide.
may I
Yes, please,
uh,
sir.
this reverse IRP in the absence of the regulations, then how the IRP and RP will be discharging the duties and the responsibilities? That is the main question, always coming up. So, because you see, the IBPI board has failed to frame any regulations, any rules as far as the working of the IRP and RP is concerned. So, what do you say? What is your intake about it?
Yeah, so your points are well taken, sir. If at all there is a provision for this, and there are rulings in this regard which enable this scenario. Not only this, there is one more, I think, Babita Gupta, Rajesh Goyal and Babita Gupta. That judgment is also there on very similar lines, wherein the promoter entity has been allowed to infuse interim finance and complete the projects. So this scenario has been enabled by case laws, judgments. But you are right that there is no, regulation which envisages this scenario and lays out the steps to be followed.
Correct.
So that can be done. That should be something which should be brought about. But at the same time, these case laws also, and both of these which we have come across, which refer to Pioneer and also refer this the later one refers to the former one. They lay down the full mechanism in which the RP or the IRP can run the project, what percentage of funds will be used for construction, what can be used for other purposes, escrow mechanism needs to be set up, all those things are there. So yeah,
the main problem which
yeah,
actually we're facing, the main issue, when the verification of claim comes to us, then
yes,
actually very difficult to verify the claim in such a situation when the amount is being spent only on the project which is actually under CIRP. So without, in the absence of regulations, working for the IRP has become very difficult, because mechanism, I understand, is defined under the the judgments. We understand, but judgment will not suffice. The issue is the IBBI should frame some guidelines, because the many of the projects are not being taken up in the absence of the regulations. For us as an insolvency professional, working on this aspect is very difficult. I'm sorry.
Yeah, Abhirup, please, you can also share your thoughts and then I'll give some
So
comments.
what if the promoter is unable to infuse any more liquidity into the project? Then how will this reverse CIRP work?
No, yeah, Abhirup, go on.
If that is a failure of the reverse CIRP, if it fails to do so, here the solvency of the promoters are very much looked into. If it is capable,
Right.
it is ready to take it, then the reverse CIRP happens. If it is not capable, not solvent to take it, then obviously it goes into regular CIRP or some interim finance is being called for.
Right. So in this case, the home buyers themselves who had first initiated the CRP and subsequently requested for reverse CRP, they were also fine with the situation. And the promoter entity had also committed interim finance. And if you look at what were the final main points of the court's final view, then it can become slightly more clear as to how this whole situation was proposed to be worked out. The Honorable NCLAT took a practical approach to reverse insolvency with the intention of saving both the interest of stakeholders and the survival of business. Reverse insolvency process is done in case of a real estate company where in a real estate project the promoter or developer wants to remain outside the CRP but intends to act as a banker or lender by providing cash flow. This act of the promoter has two benefits. First one is that the CRP reaches success in terms of delivery of units to the home buyers, is what we mean. And the second is that the project gets completed without any difficulties and home buyers would also be satisfied. So it is well known and well established that home buyers' interests are different from that of other financial creditors. They want delivery of their homes. If the reverse CIP mechanism can enable that, then the courts have held that it should be permitted.
Yeah, great. Now understood. Yeah.
So just to thank you, and just to complete the all the points on this. So the intervener, one of the promoters, was directed to cooperate with the IRP. So what you were asking, what is the mechanism? How would it happen? So there was a specific direction to them, Uppal Housing, a promoter entity, to disburse the amount apart from the amounts already disbursed from outside as a lender or a financial creditor, not as a promoter, to ensure that the project is completed within the time frame given by it. As a part of the order, the Honorable NCLAT directed and set out a time-bound schedule, mode and manner in which the infusion of funds will be made, and the balance payment of allottees, and also a schedule within which the project shall be completed and possession handed over to the allottees. Further, the NCLAT commented in its order that a secured creditor such as financial institution or banks cannot be provided with the flat or apartment by preference over the allottees for whom the project has been approved. Their claims are to be satisfied by providing the flat or apartment. There may be some allottees who may ask for refund, but that was not allowed by NCLAT. So they did not allow for refund. They did not, give weightage to pure financial creditors who are recovery oriented. They felt that the interests of the home buyers should be first and foremost. This was the summary of this judgment, and it has been, as I mentioned, similar on exactly similar lines. It has been allowed in other cases also. So this is the second case law, and probably now we can move on to the third one. Abhirup, maybe you can take that.
Yeah. So I will moving on to the case number 2. This is the kind of, this judgment is basically on a kind of treatment that has been given to a claim against land lease. So this is basically an order given by the Honorable Supreme Court in 2022 in the matter of Neokla Industrial Development Authority, that is Noida, versus Anand Sonbhadra. So what this brief background says, that in the CIRP of this 3C Projects Private Limited, there was a contract entered between this Noida and the builder or the corporate debtor, basis a bid that was floated for a land where lease to be given for 90 years and construction was to be happened for residential buildings within the next 7 years with a maximum extension of 3 years, that means 10 years. So now, in case of cancellation of the, it says that in case of cancellation of the lease due to non-fulfillment of conditions, the land with any builder on it would be reverted to Noida. Any building on it will be, so it will be given back to Noida. The land will be given back to Noida along with whatever constructions have happened. So in this CIRP, in this 3C Projects Private Limited CIRP, initially Noida filed their claim for the leased land in Form B. Later, they took a revised step to establish their claim as financial claim. They filed their claim again in Form C, and they contested that we are a financial creditor and not an operational creditor. This step, this Form C, was not accepted by the resolution professional. He said that you are Noida is a operational creditor, and the Form B, which was filed initially, is liable to be accepted. Now, on this matter, Noida contended it before the Supreme Court that the lease deed executed between this Noida and the builder is a financial lease, and as per Indian accounting system, by the provisions of section 5(8)(d) of the code, it will be treated as financial creditor. Now this dispute is whether this lease of Noida is actually financial lease under section 5 subsection 8d and 5 subsection 8f of Insolvency and Bankruptcy Code. Now this question, this has been argued in Supreme Court of India, and the Honorable Supreme Court at its order, it's ruled out the Form C and said that it is not a financial lease. It is any lease or rent is an operational claim, and it can be treated as an operational claim only. So what the summary says? The summary says that the Supreme Court referred to the various rules of Indian accounting standards which define the characteristics of financial lease. Supreme Court referred to Rule 63 of Indian accounting system. So accounting standard. So accounting standard 63 was referred for determination of this financial characteristics of the financial lease. Supreme Court also mentioned it in its judgment, I'm just quoting, unquoting, to be classified as a financial lease, what is relevant is whether there is a substantial transfer of all the risks and rewards incidental to ownership of an underlying asset. It proceeds to further hold that the lease is heavily tilted in favor of the appellant. Appellant means here this Noida, controlling almost all the aspects, and while passing over the risks, keeps the rewards with lesser, except the liberty to sell the flats which would be constructed. So it says that Noida hasn't passed on all the rights. It has only given the land to the corporate debtor with certain terms and conditions specified for the construction, time period of construction. So, it doesn't pass over its risks to the corporate debtor. So the corporate debtor has no freedom, but what he can do, he can only decide the sale price and only can sell the flats. This is what is lying with the corporate debtor. Further, the leasee would require to take prior permission from Noida to create mortgage over it. So if the builder wants to take some loans for the construction and want to mortgage that land on first pari passu charge basis or whatever it is, then also they need to take a no objection from Noida. But from it is very clear that the leasee builder does not get substantial risks and rewards of ownership, as he is not free to do whatever he likes with the plot and lands. Therefore, the lease does not qualify as financial or capital lease under section 5 subsection 8d, read with the paras of 61 to 67 of Indian Accounting Standard 116, and will not qualify as a financial debt. The Supreme Court overall found that the appellant is not a financial leaser, and in view of this, the court held that Noida is not a financial creditor and it is an operational creditor for the provisions of IBC only. So in this judgment, when this was going, the Supreme Court was already referring to the earlier judgments given by NCLT and NCLAT, who also upheld that it will be an operational claim. So the Supreme Court said in its judgment that yes, it is not a financial claim, but it needs not to be again elaborated that it is a financial claim because it is an operational claim, because it has already been ordered in NCLT and NCLAT rightly. So this claim was taken as operational claim. Now we'll move on to the next case.
Yes, so this the second or rather the third case in terms of numbers which we discussed about Noida, that also has implications across all real estate sector projects, because most of them are constructed on land that has been leased or allotted by some government authority. So this ruling clarifies the treatment of claims coming from such authorities, which can be practiced or applied across all the cases. Then coming to case number 3, and in terms of numbers, the 4th judgment that we are discussing. So this is related to project-wise insolvency resolution, which again is one of the unique things that we see in this sector, because here we have promoters who have multiple projects. Sometimes those projects are in different SPVs, in which case, company-wise CRP, if it is done, then each company will have only one project, and there is no complication or interplay of different projects, different home buyer associations, different lenders, etc. But there are situations wherein the builder is implementing multiple projects in the same company, and each of these projects is at a different stage of progress, at a different stage of execution. So this requires a special consideration when it comes to CRP of such companies. That is what these rulings seem to suggest. So once again, there are multiple case laws on this aspect. We are discussing one of them right now, which is the India Bulls Asset Reconstruction Company case. And this is again a judgment from the Supreme Court pursuant to a judgment by NCLAT. So the brief backgrounds are of the case, brief background of the case is as follows. Supertech Limited is a real estate company engaged in the construction of various projects and had received credit facilities from Union Bank of India for 500 crores towards the development of Eco Village project. Subsequently, Union Bank and Bank of Baroda extended further credit facilities of 200 crores. The credit facilities were secured through a mortgage, corporate guarantee, and personal guarantees. However, on account of default in repayment, the account of the corporate debtor was declared as a non-performing asset, and consequently, UBI filed an application under Section 7 of the Code initiating CRP against the company. The NCLT admitted Section 7 application and the IRP was appointed. Aggrieved by this order, the promoters of the corporate debtor filed an appeal before NCLAT, and NCLAT issued interim directions for constitution. Now this is important, for constitution of COC of Eco Village Project 2 only, and said that the said project should be completed with the assistance of the ex-management. Various other projects apart from Eco Village were ordered to be continued as ongoing projects. Thus, the project-wise insolvency was introduced and the constitution of Committee of Creditors was restricted to only one project, Eco Village 2, which had defaulted. So, moving on to summarize the main issues that were there. Dissatisfied with the directions of the NCLAT, the appellants, which is the financial creditors of corporate debtor, filed appeals before the Supreme Court, essentially challenging the adoption of reverse CRP or project-wise CRP by the NCLAT. It has been contended on behalf of the appellants that the appellate tribunal does not have the power under IBC. So this is the banks who are saying this, that the appellate tribunal does not have the power under IBC to allow project-wise CRP and does not have the power to accept a resolution plan presented by the promoter without giving opportunity to the COC to study the commercial viability of the plan. It has also been contended that there is no concept of project-wise resolution under IBC, and the impugned order was passed by the appellate tribunal without notice to the appellants, who are the financial creditors having substantial stakes in the matter. So we will come to outcomes and implications, but before that, again reiterating that there were the different stakeholders associated with this CD were having different viewpoints. The financial creditors were only interested in recovery. They felt that IBC, and there's an argument for that also, that IBC itself, and I think one of the honorable members in this forum was also mentioning it, the IBC, the code itself, the regulations itself, they do not provide for project-wise insolvency. But the promoters were contending that their projects were at different execution stages, that the default was restricted to this project, that they could infuse funds and complete this project. The home buyers also were of the view that only the project which is yet to be completed should be under the ambit of CRP. So the court took a view in favor of reverse CRP, and one of the justifications it gave as a preamble to its final operative part of the order was that the court needs to take a view based on, how justice is being best served. So in their view, even though there may not be such framework exactly envisaged under the code, but the intent of the code has to be kept in mind. How justice is best served, that needs to be kept in mind. Accordingly, the Supreme Court said that NCLT had adopted a particular course while observing that project-wise resolution may be started as a test to find out the success of such resolution. The result of the directions of the impugned order was that except Eco-Village 2 project, all other projects were to be kept as ongoing projects, and the construction of all other projects was to be continued under the supervision of the IRP with the ex-management, its employees and workmen. It was further stated by the Supreme Court that if on the submission of the appellants, COC is ordered to be constituted for the corporate debtor as a whole in displacement of directions of the NCLT, it is likely to affect those ongoing projects and thereby would cause immense hardship to the home buyers while throwing every project into a state of uncertainty. So they took that view that if other projects are going on fine, there is no need to bring them into CIRP and cause a state of uncertainty and thereby adversely impact the home buyers there. The Supreme Court said that it was not inclined to alter the directions in the impugned order, which means the directions of the NCLT, regarding the projects other than Eco-Village 2. The court refused to interfere with the directions relating to Eco-Village 2 project since COC was ordered to be constituted by the NCLT in the impugned order for only that project. That is what NCLT had said. However, the court said that any process beyond voting of the resolution plan should not be undertaken without specific orders of the court. So yes, they have allowed the process to be continued, CIRP process in a specific way, COC to be constituted only for the impacted project, other projects to continue to be monitored by the IRP. So the court noted that other projects were being continued by the IRP and efforts were being made for infusion of funds with the active assistance of the ex-management, but without creating any additional right in the ex-management. So here again, the promoters were co-opted into the whole process because their support, or rather their execution and their execution efforts and their fund infusion is required to allow the project progress to continue. Keeping these things in mind, this judgment was passed. So again, very unique situation here, reverse CIRP, project-wise CIRP, home buyers as FCs, all these things, and coming out through various judgments as well.
Right, Shalini.
I think this concludes this part of this judgment, and we can, Abhirup, you can
Yeah,
take up
we are
the.
moving on to the fifth case. Here the case number 4. So this judgment is, this judgment relates that I was in this first few slides of this PPT, when we are talking about the timelines, we are mentioning that the 90th day is the final timeline for submission of claims. But I mentioned at that point of time, that even we have seen that the court gives ample chances to the claimants, especially to the home buyers, so that they get their homes even after they claimed after post 90 days. So this judgment refers to that position only, where the delayed claim were rejected by the resolution professional of KV Developers Private Limited, and now then after that this Alotti moved to NCLAT with an appeal to take his claim. This is judgment given by NCLAT New Delhi bench in June 2022. So, to give the background that a few developer, if few home buyers, they are the allottees in one of the projects of KV Developers Private Limited. The resolution professional did not accept their claim on the ground of delay. But ideally, the information memorandum ought to have included the information of all the home buyers who have even not filed their claims. But in this case, this did not happen. So the successful resolution applicant could not put any provision, in their resolution plan for these, allottees who missed to file their claim within the timeline, because this was not in the information of the given to the PRS, or rather when it converted to successful RS, the one. Now this aggrieved home buyers, they moved to NCLT, who also rejected their claim because they said that the plan has already been passed. So at this belated stage, your claims cannot be taken. So they moved on to NCLAT with an appeal against the RPA and COC and the successful RA for rejecting their claim on the grounds of delay. There are several judgments actually. Sorry, there were several IAs actually, but all were clubbed together and heard in the same hearing, and the order was given under this judgment only. So when the Form A was published, the issue is that main issue is that when the Form A was published, that mentioned a specific timeline of 14 days. After that, it also allowed a timeline of 90 days. Till that time, these home buyers, which is around 50%. I mean, I think it's 450 or something near about the total homes, and around 225 or 230 couldn't file claim. So it's more than 51% who couldn't file claim in this particular case, because they were unaware that we also discussed before, that we see a large number of allottees who actually lives outside or somewhere. Not they don't get information about the insolvency, and that is why they can't file their claim. So they also stated it in their application that they reside outside Noida, so they could not have learned about the CIRP, and hence they could not file their claims within the time. Now in this situation, the resolution plan was already passed. So how to deal with these claims if we'll have to take it? Now the NCLAT in its order said that these are the rights of the allottees, and they are bound to get this allotment even if they have not filed the claim. The NCLAT allowed and observed that due to an inadequate publicity regarding the initiation of CIRP, the home buyers are not aware about the public announcement. Oh, here comes the number which I was discussing. Out of total 473 home buyers, allottees, only 222 could file claim and 251 didn't, which is a substantial number, around 60% of the entire allotment capacity of the project. So the resolution NCLAT directed the resolution professional to provide, and he also mentioned that this in its judgment, when giving the judgment, NCLAT mentioned that it was the duty of the resolution professional to provide the complete data in the information memorandum, not only for the claimed units but also for the units that were sold but not claimed. So the list should contain the full allotment details, should have contained, which the information memorandum in actual did not. So it directed the resolution professional shall provide all details of home buyers along with their claims as reflected from the records of the corporate debtor. Here comes it, the records of the corporate debtor, because these 251 units are not claimed. So you have to take it from the records of the corporate debtor who had not filed their claims, including the appellants, to the resolution applicant within a period of 1 month. So within a 1 month, they should provide such list to the successful resolution applicant. The successful resolution applicant shall prepare an addendum. So it is said it has to be prepared. They has to prepare an addendum to the resolution plan submitted to the resolution professional and place the same before the COC within a further period of 1 month. The COC shall consider the addendum in its meeting and decision of the COC on the information memorandum and addendum be placed before the adjudicating authority, that is your NCLAT. The COC shall take the decision in its meeting within a period of 1 month after that, by after submission of the resolution addendum by the resolution applicant. The adjudicating authority, while considering approval of the resolution plan, which is pending consideration, shall consider the addendum and minutes of COC at the time of finalizing the resolution plan. So here NCLAT also instructs the committee of creditors to revisit the addendum and information memorandum, accept that, and place that addendum to NCLT where the current resolution plan is pending for its final approval. And NCLT also have to consider that addendum along with the resolution plan that has been original resolution plan that has been approved by the COC. So this this is a case, and the another case with our experience that we have advised to one of the real estate sector RPs. There also we have seen that at a belated stage, when the resolution plan was even approved by the COC and it was just pending for the approval of the NCLT, in that case also NCLT itself ordered the resolution professional to accommodate the claims which have been belatedly filed in the existing resolution plan. It has also advised or ordered the RA to take the claims that were received from the home buyers at a belated stage, because it is very they are very much in favor of home buyers to take their who can who are aggrieved because of only rejection of their claim due to delay, because they want to give the rights and the homes to the home buyers. So this is the first preference. That is why even of such delay, even after filing of claim, even after preparation of the resolution plan, they were told to be accommodated. So this completes this case over here. So this case number 5, it has already been discussed by Shalini, which treats the home buyers as financial creditors. We'll quickly move on to the 6th case. So this case is regarding one of the government authorities who objects on a resolution plan in the capacity of an operational creditor. So this is in the case of JP Infratech, where this government authority EDA, that is Yamuna Expressways Industrial Development Authority, they filed a claim in the capacity of operational creditors, and when their claim was admitted, it was admitted to a shorter amount. and when the resolution plan submitted, it allotted, it made another haircut to the admitted amount. Then this either took gave an objection on the resolution plan, and they said that such kind of haircut and concession cannot be allowed to the resolution applicants in its resolution plan. So just the background is that either filed a claim of around 6,000 crores in the JP, in the CRP of JP Infra, out of which their claim for 461 crores pertaining to external development charges were admitted. Rest of the claims were some in grounds of future works, not future works. Some was in ground of additional compensation. So these kind of claims were, not admitted by the resolution professional. But still, a provision for payment of 10 lakhs were made. Out of this 461 crores against EDC, which was admitted, the resolution plan provides 10 lakh of payment. Additionally, the resolution plan also provided 10 lakh of payment towards the towards the claim filed against additional compensation, though it was not admitted by the RP, but it still provided 10 lakhs. So either has filed an application because they had a concession agreement signed with JP Associate for the development of Yamuna Expressways for the next 36 years. As per EIDA's appeal, the remaining amount of claim cannot be extinguished as a relief to the successful applicant by payment of only 20 lakhs together. So basic issue here is to determine whether at all this 20 lakhs payment can be appropriated against the total compensation asked by EIDA and rest of the amount being written off. So here NCLT NCLT heard this matter, heard both the parties, went through the concession agreement that was signed for 36 years between Yamuna Expressway and JP, and they judged it in a manner that it is very much clear that EIDA is a statutory authority and they have filed their claim as operational creditor. While it is very much clear that any resolution plan, any of these government authorities has right to have comment or to verify the resolution plan, any statutory body has this right. But on the other side, it has to be also kept in mind that it is a government body, is an operational creditor, and they don't have the right for negotiation of a resolution plan. So what it says in its judgment, excuse me. Yes. So what it says in its judgment, I'm just quoting. It is a matter of fact that EIDA, though an authority, being an operational creditor, is not a part of the COC of the corporate debtor, which alone is empowered under law to consider and approve or reject a resolution plan on commercial terms. However, under the provisions contained in Regulation 37, Regulation 1 of IBBI regulations, approval of either Yamuna Expressway is still required as an authority if any of the proposals in the resolution plan seeks to alter the terms of the concession agreement. So if there is any alteration in the 36 years agreement, alteration of terms in the concession agreement, then obviously this resolution plan would have required approval of Yamuna Expressways because the original agreement is with Yamuna Expressway concession agreement. However, this does not give the right to the authority. It is also stating that it doesn't give the right to the authority to negotiate with successful resolution applicant that if its claim is not fully discharged, it shall object to resolution plan. So they don't have right to object on the resolution plan on account of negotiation. In our considered view, what EIDA can get directly as an operational creditor, it cannot get indirectly under the attire of being an authority. So although it is an authority, but what it can't get as operational creditor, it can't get even being an authority. So the right is same. as an operational creditor. So it also says that in the instant case, if we ignore the reliefs and concessions sought in the resolution plan for a moment, then in our view, we found no such provision in Suraksha's resolution plan, who is the successful resolution applicant, which is in violation of the terms and conditions of the concession agreement under the reference. It has also been noted further that the proposal regarding extinguishment of claim of IDA in the resolution plan, because of it being operational creditor, does not amount to violation of the concession agreement by the successful resolution applicant, as the same is being effected due to operation of law. So it continued to say that further the act that under the provisions of IBC, NCLT has no equity jurisdiction. So there is no equity jurisdiction is NCLT under the code. It can neither interfere within the commercial wisdom of the COC, nor it can go beyond the provisions of the code. Since IDA itself had filed its claim as operational creditor, and the liquidation value owed to the operational creditor is proposed in the proposed resolution plan is nil, and the SRA, successful resolution applicant, has still provided amount of 10 lakhs for this contingency in its resolution plan. Contingency means the additional compensation that was not admitted, but it was put as contingent, and a 10 lakh was assigned against that. So the NCLT found no illegality committed by the successful resolution applicant by treating the claim of IDA as an operational debt and making provision towards its payment in accordance with the provisions of IBC. And in fact, the provision of IBC says that whatever amount has been allotted to all the type of creditors in the resolution plan which is approved, that discharges the complete liability of the corporate debtor to all such claimants or creditors. The NCLT in its observation also mentioned that in Suraksha's reply, they have said that they are willing to execute via all the future works. So as I said, the 6,000 crore claim also includes some future works, which was claimed as in contingent manner, whether the successful resolution applicant will complete them or not. So it was just an estimated claim. So that was also rejected and said that the successful resolution applicant has mentioned in their resolution plan that their future works, they will complete under the same concession agreement, under the same terms and conditions, and the dispute with regards to the costs pertaining to unexecuted external development works and other future works requires no adjudication. So the resolution plan was, JP's resolution plan was finally approved by NCLT. So in JP's resolution plan, when it was, objected, so there are many things on security part also either gave an objection, and there are other aggrieved creditors and other banks also, other financial institutions, government authorities has also, have some objections, but all were heard together in this judgment. So I have just summarized one of the objections that have been put by either in the capacity of an operational creditor to on the approved resolution plan. Their objection was ruled out because they are still, although they are adjudicating authority, statutory body, but as there is no change in the concession agreement what was made with them, so they can't do a their approval are not required, and they can't do a negotiation as the right only limits to the COC. So this completes this case, and we'll move to our last and seventh case.
Yes. So just some finishing remarks on the previous case which Abhirup explained. So of course it is very much applicable in real estate projects because many of them are granted under concession from a government body, but it is also applicable in various other sector projects because quite often there is a concession agreement or a license agreement from a government authority which is the commercial basis for the operation of that project. So this judgment, Abhirup has already summarized the points, the key points, so I'm not repeating that. But the fact that the NCLT upheld that yes, the authority's claim can be treated as OC and only the provision which is made in the resolution plan should be allowed for it, and that does not tantamount to modification of the concession terms. This is a very big takeaway which can be also used and referred in multi-sector projects wherever there is an interface with the government authority. So just wanted to highlight that. And yes, now we can discuss the last key judgment that we have with us. So this again, the whole theme of financial creditors in a real estate project, home buyers being part of the COC being treated as FCs. This is very closely linked to that. This is one of the judgments. We have found other judgments also similar to this, which give a similar treatment. So coming quickly to the facts of this case, the background, TGB Reality came up with a public invitation inviting the general public to invest in buyback scheme of the company and also buy apartments in their project TGP Neel Gagan situated at Ghaziabad. The petitioners were the buyer of one apartment under the said buyback scheme, in terms of which after 36 months from the date of sorry I think somebody needs to go on mute, whoever is not speaking. Yeah, so I'll continue. The petitioners were the buyers of one apartment under the said buyback scheme, in terms of which after 36 months from the date of agreement, the allottees had the option to surrender the apartment and the respondent could buy back the same. In the case of buyback, the builder was supposed to pay back the allottee an amount of the sum paid by them, along with an interest of 24% per annum. On the 35th month, the co-allottees demanded the sum paid by them, along with the interest under the buyback scheme, which the builder refused to pay. So the co-allottees filed a petition before NCLT under Section 7 as financial creditors. So let us see what, how the court dealt with it. So before that, the arguments from the other side, the bidders, the builder, they had to say that the co-allottees had raised the demand as per clause 8 of the agreement only after expiry of 35 months, and thus they were not entitled to any payment from the CD in the name of buyback consideration. The co-allottees did not pay the amount required to be paid and so failed to comply with the terms and conditions of the buyback agreement. The counsel for the respondent tried to repose that the allottee, being himself a defaulter, cannot be entitled to any relief, including payment of consideration or refund. The amount of default being less than threshold requirement, the petition deserves to be dismissed. It is not the object of the IBC to penalize solvent companies. In such cases where the clauses of the agreement specify buyback, the purported allottee who seeks to benefit from a lucrative agreement, the agreement has to be perceived only as a camouflage of actually financing the construction of the flat. In view of the judgment given by the Honorable Supreme Court in Pioneer Urban Land Infrastructure versus Union Bank of India, would fall in the category of speculative investor and not a person who is genuinely interested in purchasing a flat. So the principles for considering home buyers were already, for considering home buyers as financial creditors were already outlined in the original judgment which upheld their treatment as FCs. And if we go by those principles, then the parties who are only investing in a flat for the sake of investment are speculative investors or speculative buyers, not genuine home buyers, and cannot get the same rights. That is what is the sum and substance of the judgment, the outcome of the judgment, which is mentioned on the following slide. Finally, the Honorable NCLT said that the allottees sought to benefit from a lucrative agreement. I think there's a slight repetition, but I'll just go over it quickly. So they sought to benefit from a lucrative agreement because they were securing their money by way of the agreement. And the home, in normal circumstances, this is not what happens. The home buyer is, a normal home buyer does not have a choice. As per the builder buyer agreement, the home buyer does not have any option of exercising his choice of taking or not taking the possession. In a normal builder buyer agreement, if the buyer does not accept the possession, his EMD is forfeited. But in this case, the buyer was being committed his original principal plus 24% assured return, even if he chooses not to retain the apartment. Thus, the agreement is only a camouflage of actually financing the construction of the flat, not for the purpose of taking its possession and residing in it, but for the purpose of only investment returns. The builder had also agreed for a settlement of the principal amount paid by the allottees. So NCLT relied again on the judgment given by Pioneer Urban Land in the matter of Pioneer Urban Land Infrastructure, which set out the framework for considering home buyers as FCs, which mentioned that the allottee who has knocked at the doors of the NCLT is a speculative investor and not a person who is genuinely interested in purchasing a flat or apartment in this case. They can also point out that in a real estate market which is falling, the allottee does not in fact want to go ahead with its obligation to take possession of the flat under RERA, but wants to jump ship and really get back by way of coercive measure. They saw the filing of the application as a coercive measure to get back the monies paid by it. Given the above, it is clear that it is very difficult to accede to the petitioner's contention that a wholly one-sided and futile hearing will take place before the NCLT by trigger-happy allottees who would be able to ignite the process of removal of management of the real estate project and or lead the corporate debtor to its debt. For all the aforementioned reasons, the order of admission under Section 7 is set aside. So, this is an important judgment because while home buyers have rights, speculative investors do not have any rights. This is one of the judgments. There has been another judgment, Shubhra Sharma versus Mansi Brar, which also reiterates the same principles that only a genuine allottee can be considered as a financial creditor and a speculative investor cannot be. So this is also a safeguard for real estate companies. This, I think, brings us to the conclusion of the section on judgments. I think we have covered most of the key ones pertaining to real estate CIRP and touched upon all the relevant issues here. OC claims, authority claims, treatment of home buyers, reverse CIRP. And then we can, come to the concluding section, which is basically why we, I think this is, again, tying up to the main objective of this whole knowledge session. One, real estate sector stress projects constitute a huge chunk of the stress sector projects in the country. As per a recent report, we all know that real estate is the main contributor to GDP, and it has faced troubles in the recent past, but now seems to be back on track. At the same time, the stress in the sector continues to be very high. According to a recent report, there are almost 4 lakh units in India, across India, which are facing stress, which are facing delays. A large chunk of these are in the metro cities, Mumbai, Delhi, etc. So these challenges exist. It is important to provide the right framework to deal with the sector's resolution through IBC. It is important to provide the right framework to deal with the claims of home buyers and the rights of home buyers through the mechanism of IBC. It is an evolving process, but a lot of attention is required. There's a recent report by the government, and there are recent reforms being proposed. I think earlier one of the participants mentioned that there is no detailed framework in the code itself. I think there is thinking from the government on those lines. It is some of the things that we spoke about. For example, the main objective of the code is to give delivery to buyers. So registration of flats should be allowed during CRP. IRP should be allowed to carry forward the construction. IRP should be allowed to file claims, to file an application, consolidated application on behalf of claimants who are delayed in filing their claims. All these things are at discussion stage, but are proposed to be brought into the ambit of actual reforms and guidelines, which will help to resolve and look at the issues in this sector. So I think that is where we conclude in terms of thought exchange. Abhirup?
Yes, and also so just wanted to add, I mean, Swami Fund has also been introduced. This special window for affordable and mid-income housing. This fund, uh, sponsored by our finance ministry and is managed by SBI Cap. So even for, we have seen in many cases that they are funding to this projects which are for the mid-income groups, and in many of the CIRPs where the resolution professional is carrying on the construction with the help of development manager or whoever it is, they are also trying to have investment through this fund for carrying out the construction. So this is a good fund that has been implemented, and around, a report says that around more than 20,000 homes have been uh, handed over with the help of Swami Fund since 2019 when it was introduced. So this is a good step that has been taken.
Right. So we can have some quick questions, but in terms of questions that were already raised, I think we have already touched upon the points related to decrease, related to delayed compensation. There is one point, Abhirup, whether you would like to, dwell on it. I think there was something similar which we encountered in one of our projects. Though Mr. Agarwal, Mr. Sharma, if you can clarify more on what exactly your question is, this one. What is the relevance of JDA-JV agreement between the developer and the landlord in the context of a resolution plan? Is the resolution plan binding on the landlord? What if the landlord does not sign the document? Registration of the apartment in favor of the home buyers. RA, can the Honorable NCLT direct the RP to sign the documents?
Okay, so we can take the questions.
Yeah. So I think there was something similar, which was touched upon in the judgment on Noida, Yamuna Expressway also, because that clearly mentions that the role of an authority as an authority should not interfere with whatever its rights are as an operational creditor. So in case there is an authority which is required to sign off on certain documents as per its normal contractual obligations, then that does not get interfered with as per our understanding. But maybe you can clarify your question more, Mr. Sharma, and Abhirup, maybe you could also respond to it.
Ma'am, the question was raised by me actually. I'm Josie Stephen here.
Oh, sorry.
Yes, sir.
My question
thought
was
it was
actually
Mr.
if there is a normally there is a JDA, between the landlord and the developer, and because of some dispute between the developer and the landlord, and if the landlord is not agreeing to the resolution plan and he is not ready to execute the registration documents, in that case, what the RI will do, whether the order from the NCLT will have an enforcing power, so that the RI can go ahead and take care of the complete project, and do the necessary documentation. So what if completely if the landlord is not cooperating, and how this will go ahead? That
So,
was
sir,
my
this,
question.
yes, sir. So, see, this in this joint venture where there is a joint development agreement is there between this landlord and the builder. There, we already have a signed agreement from both the parties. Now, when it has gone into CIRP, the resolution plan has been submitted. If the resolution plan has been passed by the committee of creditors, which will also include the home buyers, if that is passed, then the landlord, whosoever it is, he is bound to sign on the registry. And if he doesn't, it can be taken through NCLT, because the resolution plan is the final one and it concludes the CIRP if it is being approved by the COC member and as well as it is approved by NCLT.
Right, I agree. It would have a binding effect. It should have a binding effect on all stakeholders, including the JDA counterparty.
So that means the RA has to honor the JDA between landlord and the CD, or that JDA agreement can be forgotten.
No, JDA agreement he has to honor. I mean, it has to be, when the resolution plan is getting prepared, when they prepared the resolution plan, he must have, in case of a JDA, if it talks about alteration of the terms of JDA, then the approval from the counterparty is required. But if it doesn't alter the terms of the JDA, then I think the normal resolution, the normal approval process is sufficient. Like in the case of IDA, what the court has commented that if there was a change in the concession agreement, terms and conditions of the concession agreement, then an approval from IDA was required. But the resolution plan keeps the terms and conditions same for the future work. So there is no concession further has been asked by in the resolution plan. So there is no objection which can be granted from IDA. So in this case also, if the JDA, whatever terms and conditions in the JDA joint development deed, whatever is there, if those provisions and the resolution and whatever there in the resolution plan, if the resolution plan doesn't hamper the interest or rights of the landlord as said in the JDA, it can go ahead and even if after that the landlord is not ready to sign, the SRA can approach to the authority for a direction.
I'm not clear on this, because JDA agreement, there is a JDA agreement, and there is a in the JDA agreement, naturally there could be a profit sharing between the landlord and the developer. Okay, so considering there is no claims received from the landlord in this process, but when the resolution plan comes in and the resolution applicant, imagine if he is not giving any money to the landlord because there is no claim. So when we say there is a JDA agreement, the construction, imagine construction is completed, project is ready, but the company CD is into CARP, and the landlord has not put in any claim. So at the time of resolution plan approval by the COC and NCLT, there is no claim from the landlord. And if the landlord is not, this is a theoretical or hypothetical question I am putting into. If the landlord is not agreeing to sign off the registration documents, because in the resolution plan, there is no consideration for him. In that case, can the RP sign the document by taking an order from NCLT or not?
No, sir. So, I mean, here, see, the terms of JDA has to be very clear. Whether in case of this joint venture, whether the landlord and builder, whatever company is for building this, does that, is that a joint venture between this builder and a landlord, where the landlord equally have contribution to the building? In that case, the ratio, there should not be a claim, because see, he is also a part of this building activity in that case. So he should not file any claim. Like the builder, he also getting the profit. But does he file claim for his profit?
Correct.
In a CIR, it's not. So the
So there is
in
no
this
claim.
case, if it's a JV, the landlord is not supposed to file a claim because he's a
Correct.
part of the JV. He's a joint venture. It's the
It's a CD
equal
asset now.
contribution, equal distribution by the builder and the landlord. So it's absolutely correct. So if nothing has been given in the plan by the resolution applicants, I think that
Anyway, I think
the
specific
landlord will
agreement has to be
definitely
looked
contest
into.
on it because this is violating the terms of the overall joint venture. So it's a joint venture, not a. The other thing could be that the landlord had gone into a JV or joint development agreement. If I don't think it's a JV, then in that case it's a different matter altogether. That sometimes it happens that the landlord gives power of attorney to the builder to build a construction over there, where he will receive some kind of compensation. I mean, not compensation, some allotment, or maybe in terms of money or whatever ratio it is. So in that case, he needs to file a claim. But where it's a clear JV, where he has armed with the builder, then he is not required to file a claim. His profit sharing, how it has been decided in the JDA, that has to be, somehow attended in the resolution plan. It may not be in full, but somehow it is to be attended. I mean, given. Otherwise, it is quite common that the landlord will always go against it and they will file in court.
Thank you.
Any other questions that
Sir,
we have?
one small question actually. In the beginning of the presentation, you had mentioned that the allotee of a flat actually is a secured creditor to that extent because he has a charge on that flat. But under the code, I think he is treated as an unsecured financial creditor. So is this not an anomaly? Has it not been contested in any kind of a litigation?
Absolutely, sir. Absolutely. If you go see what we have covered in this, what we have said, it says that buyers are entitled to a charge on the property to the extent of the purchase money paid by them, along with the interest. However, they are continuing to be treated as unsecured creditors, subject to the agreement for sale as per market practice. So yes, you are absolutely right. This is one of the areas that which could be looked into, and even if required, this needs to be addressed and amended because the whatever allotment they are being given, they are very much secured against that allotment. The money which they have paid is very much secured to that extent against that unit.
Right.
The builder can't sell that unit to any other person, so that is a very much security that has been ensured to the home buyers, but it is still being treated as unsecured, which really is an area of suggestion that we can think through. IBBI can think through and have an amendment or clarification further to treat them in a secured manner.
Has this not been contested in any litigation up till date?
So this
So
is
far,
not
I do not recall.
right.
Yeah, sorry, this is Ravichandran here. Sorry, I lost this compensation regarding this rent or interest. I lost that again. I'm sorry about it. What is that decision?
So that's a different point.
So compensation against rent. So what we told that firstly we have to analyze whether the whatever compensation has been allowed, that is whether that is financial in nature as given in the claims, as given in the code. So financial means, I mean, whatever money has been given, if that compensation belongs to time value for that money that has been invested by the home buyer, in that case it is a financial claim. But if it is a claim for the renting, so it may not be directly allowed as a financial claim.
Okay.
Because this is not something a financial assistance that the home buyer has done to the builder.
Okay. Even interest also.
No, interest forms a financial claim because the IBBI regulation 16 says that they are eligible for interest, and if any interest is not agreed in the agreement, then it should carry 8% interest
8%,
on the amount paid. So interest is a nature. interest should be added to the principal amount paid by the home buyers in the financial claim.
Thank you. Thank you. Thank you.
Sir, I have a question. This is Prajakta. So if there's some issue with the video, I can't activate. My question was while we have been using the term home buyer to use this in context of financial creditors in a class, assuming it's a commercial allottee under RERA, and say he's been allotted under some industrial park, are there any issues in recognizing him in a class, or he invariably falls in the same category as a home buyer? Not in the residential, but on the commercial side, because he's an allottee under RERA, or because I have come across some issues in terms of industrial unit coming under the ambit of RERA. So what if the real estate development company is into a commercial project, and all these allottees are corporates who want to run their business out of that particular commercial unit?
They can be treated under the same financial as
So
the
there is
financial.
no issue, because there is
There is
some
no-
RERA judgment which says that industrial unit is outside the ambit of RERA. So how far this has repercussions in terms of IBC?
No, industrial units may, you know, maybe out of the ambit of RERA, but
Yeah.
IBC covers the same mechanism for financial claims. So it's simply, madam,
Right.
to clarify,
Right.
as per the code, if the nature of claim is financial, if it carries a time value of money, if it is a clear assistance or investment of monetary value, then
Right.
it is a financial claim. Be it in an industrial sector, industrial construction project, be it in a residential construction project, be it a commercial plot in a residential project. So whatever it is, it could be a commercial plot as well in a residential project.
And
But
in a
when it is
situation,
an exchange of money against an unit, it comes under the same ambit and it stands as a financial claim.
understood. And in a situation where suppose I have paid full money, I have received the possession, but conveyance is not done. In such case, do I have to file a claim form, or how do I reinstate my rights?
Yes. So in order to inform the RP and the resolution applicants
Hmm.
that although I have paid the money, but I haven't got the keys, I haven't got the registration, so the unit is yet to be delivered to me.
Right.
So I still owe the money back from the company until the unit is delivered to me and it is registered. So ideally, I should file a claim.
And that would be in Form CA.
That would be in Form CA.
And in the situation where I'm just claiming damages or say some penalty, then
Ideally, it
for
should be
delayed possession?
ideally it should be in Form F as other creditor, because that doesn't have direct financial implications. I mean, financial value.
So in a situation like I just described, where I have got the possession but not the conveyance, and I still owe some damages from the company, then I have to file under Form F preferably, is what you're suggesting.
For that portion, but for your principal amount which you have paid, you need to file it in Form CA.
Understood. So even though, but technically the ownership is mine, so the RA has to recognize my rights. It doesn't remain the asset of corporate debtor in that case.
Absolutely, it is your asset. But until and unless the registry happens, see, you will have to get the registry done through the RP IRP, or if the RP IRP cannot do it, you have to do it through the successful resolution applicants. So this
Yes.
information should be clearly passed out to them. So see, if you have paid 70%, or if you have paid 100%, or if you have paid 10%, is irrelevant.
Okay.
Until and unless you have got the position on registry, you should file your claim. Otherwise, it will create a lot of litigations. When we have already covered in this session, we have covered a case where this allottees, this allottees were not allotted with a flat, who could not file claim,
Hmm.
who did not file claim, their
Yeah.
claims were being not taken by the SRA because it was missed in the information memorandum. Even
Right.
if it is given in the information memorandum, then also the SRA may decide not to take any of the claims, because they can say, if the allottee doesn't take the ownership of his own dues, why should we take it additionally? So that is why it is always advisable, whatever percentage of amount you have paid, until and unless you have got your allotment as registered and you have got the position, please do file your claim in Form C.
Okay. Then it is up to the discretion of RP. He may say that since you have the possession of the asset, the company is not owing you any debt, and he may reject.
Yeah.
He may reject the claim, right? I mean, that would be the discretion of RP in that case on how he treats this particular transaction where entire money is done, possession is received, and he may say technically there is no debt.
So, ma'am, just to interrupt, ma'am, if the possession is received, I think that's a different situation.
I was
What
thinking
Abhirup
he
is
didn't
saying,
take the possession.
yeah.
Okay. Understood. Thank you so much.
Anyone else?
Can we have a copy of the presentation mailed to us, please?
I think we can send it to ICICI. They are the ones who send it to the group. So we can do that.
And lastly, I have a question if nobody else has any question. 1 minute. Hello?
Sure. Yes, yes.
Yeah, for example, in case there is a title deed in favor of a home buyer, already there is a deed in his favor, then can he be a part of the COC? And
No.
Meaning there is no NOC from the bank.
Yeah. So I think you had put the question on the chart also.
Yes, I had put that question.
Yeah. So Abhirup sir is saying that the owner has got, the buyer has got the flat, but he hasn't got an NOC from the previous bank. So this is so in this case that means the project is constructed, right? Is it
Project
a secondary
is constructed.
stage?
Project
Yeah.
is constructed. Deed is registered in his name, but the creditor, financial institution, who is a part of the COC, also he has not given the NOC to this particular buyer.
So Abhirup can add, but in my view, if he has already got the flat, then he is anyway no longer an allottee, and there is no question of him being on the COC.
But the
Sir,
possession
here,
is,
NOC
if there
is
is
a
no
separate
NOC,
matter.
then the possession is still with the bank, ma'am.
No, NOC from whose bank, sir? NOC from his, did he take
CD's
the
bank.
home loan?
From the CD's bank.
From the CD's bank he didn't. Sir, CD's bank, if he hadn't received NOC from the CD's bank, he should pursue for that. But as the deed has already been registered, then that unit is his. That is a procedural gap that the NOC has not been come. So ideally, the NOC is to be taken at the time of allotment only. It should not wait even till the deed registry of the sale deed. It should actually taken at the time of allotment only, because otherwise all the units are being mortgaged to the CD's bank. So any allotment needs prior approval from the CD's bank. So if it has not been taken, it is a procedural gap. But for that, he can't sit in the COC only, but he can always approach the RP through the RP to CD's bank to get his NOC done. That is a procedural matter.
Okay, thank you.
So if we are at the conclusion, then I would request ICICI to conclude the session. And of course, thank you to everyone for joining, and thank you to ICICI for giving us this opportunity.
Yes.
Thank you. Bye.
Thank you. Thank you, everyone.
Thank you
Have
so
a nice
much.
day.
Thank you very much.
Bye.
Yes, have a nice day.